So we are going to keep moving right along, and we are going to jump and talk with Carey DeWitt, who is a shareholder at Butzel's Lawyer and Counseling Office in Troy. He is a dual graduate of University of Michigan and Michigan State. So fun at your house on game day, right?
Oh, all the time.
And your background is in labor employment department, but you've been a lawyer for 39 years, and we've already had some.
Education lawyer, Kevin. Thank you.
Okay. And we've already had some really good conversations. And I think one of the things here in Michigan, we've talked about it in previous conversations on bullying, is, we have a law. Actually, just about every state now has a law on the books about bullying. And this is a law that I helped pass. It's named after my son, the Matt Epling Safe School Law. And it was passed in 2011, 12, and we had to go back. We had to add cyberbullying to it. But I think there's just has been some confusion as to, is it really kind of living up to what it's doing? And we're going to talk about that, but people in other states, this will probably give you some information where you could actually go and look up your own state law as well. So, Carey, I thank you because we had a great conversation on this earlier, and just to kind of get us rolling, I can let people know that here in the state, the law has like a section that any policy made in the school has five. In section 5, there are certain components, it must have that. So it must have, a statement prohibiting bullying, that prohibiting retaliation, a provision indicating everyone's protected, identification of job title by a school official who will handle this, how the policy is to be publicized, distributed, and a procedure for providing notification to parents, a procedure for reporting acts, procedure for investigation, a procedure for keeping a report and giving those to the school board members, and of course, keeping things confidential. We found some schools probably really aren't doing all of these steps. How does that kind of sit, and what does that mean for a school if they're not doing these?
There's a pretty well-established doctrine, Kevin, in most states, so this is easily applicable outside of Michigan, typically, that if the defendant in a civil suit owed a duty to the plaintiff, here a school to a student, clearly the case, then the prescriptions of the statute as to what is to be done in the area of that duty, here publicize your policy, create a policy in the first place, report to the public, report annually to your community, ensure that there is not retaliation and so forth. Those are all things that could allow an aggrieved victim to say, you did not follow the policy. You didn't do the things, Kevin, that you described a while ago, and the statute has now described the duty, whereas it didn't before. The statute says you have to do these things in order to protect students from bullying. And if you had a bullying victim that could be said to have injuries proximately that is reasonably caused by the non-performance of the duties set out in the Michigan anti-bullying law, Matt's law, then the defendant school district could easily be liable for non-compliance in negligence, as well as other potential problems.
And by doing those and having a record, because everybody likes records, having that record, you can go back, if you actually have that in place, to say, we have been doing things. And I know as kind of on the advocate side, and because I really try not to kind of beat up on schools, because we have to help them as well. They're part of the greater community. But, I know parents who have been going through an issue, say with the school district for months to kind of resolve, what happened, during a specific incident. And so I always say to parents, the best thing you can do is look at the law, look at the school's policy, and compare those and go talk to the school. Is there anything else that, a parent, can do? And is it start with the teacher, start with the principal? Are there things that a parent can do?
Yes. Use a checklist of the requirements that you set out, and there are some more detailed requirements, as you know, in the statute. And ask the school board and the principal and the administrators to report. It doesn't have to be hostile at first. They know this is a statute, and they know also, and I think this is one of the relatively serious teeth, there aren't a lot of them, that the statute has. And that is, you have to provide your policy to the Michigan Department of Education. You have to have a person that is identified as responsible for this. Have you done those things? If so, can we see how? Now, from the point of view of the school district, I recommend an electronic notebook, okay, of compliance to prove that you've done these things, because these are legitimate questions. People get questions about all kinds of policies, your sexual harassment policies, for example, your wage hour policies. That there are various acts that you need to take to comply with these things. And if the school district is ready with the policy, the reported individuals, the website, okay, and when the last time there's been a report to the Department of Education, then it's going to be able to answer those questions, and they're more than fair to ask.
Yeah, and I think another part in Matt's law, and maybe in other state laws too, is that it's that the Department of Education is supposed to set up also a way to kind of collect and a process to do that. And I think what we've gotten into is kind of, well, if the department doesn't do a process, the school district may think they don't have to do a report. So the report doesn't get done because they don't think it's going anywhere. So I always kind of, my mind goes back to the movie Office Space. Has this now just become, our TPS reports that nobody's really doing them. And does that set them up for liability?
It can, because you don't, that's a sign of non-compliance. And if the right thing is not identified, is not described, there's a far greater possibility in the mind of a decision maker that there's general indifference to the statute. Which school district would you rather see? One that's really not reporting, okay, even if they're trying to do the right things, or one that's doing the right things and is reporting properly? Some of the requirements of a proposed statute we may be talking about try to address the collection of information.
And I think that is something we have talked about in going back and making kind of changes. As you said, are there teeth, and does there need to be teeth? But also totally understanding, as you said, how many other reports and how many other things that schools are responsible for. And we do have to kind of weigh that, we can't just continually ask. And how do we maybe even combine, some of these reports? So there are ways to do this, and it's not like putting an onus on the teacher, but it really is the schools. And I think a lot of schools I see it kind of goes to the responsibility of the superintendent to understand the schools in his or her district. And is that something even a parent should think about going just to the superintendent, because they're the key person?
Definitely. And I understand the burden of various regulations on school districts, but there is a way for school districts to address all of the various requirements applicable for them. corporations in the United States established compliance programs 25 years ago, and they basically list all of those obligations. And here's what we're doing. It is burdensome, but the legislature of the state of Michigan has decided that this is an important policy and they have to comply.
And I think that's where, we have to go back and into this, say, we have to make some changes. We have to do something sooner than later, because we've had a long time to kind of go through this. And as with everything, even when we were talking about trauma learning, this is kind of like trauma learning. We're at the end of this of 12 years. We're going through and trying to find where things kind of fell through the cracks, to go back and say, we have to kind of fill these in now to really help our kids.
A good example of that is the reference you made to cyber bullying.
Right.
And Kevin, you would know more about this than I, but I bet you the provision that said that a device used in bullying would have to be owned or controlled by the school district in order for the definition of cyberbullying to be satisfied under the statute. Because I think the districts probably said, we don't have any control of what happens at home.
Right.
And the proposed legislation, which might or might not be adopted, tightens that considerably and could be adopted. Obviously, there needs to be notice in some way about abuses like that. And I don't think you and I could cover this topic adequately unless we reminded parents that they need to be vigilant about what's going on with their children with those devices. There are lots of bad things that could happen, and this is one of them.
100%, and that's one of the things too, and being able to try to get cyberbullying into the bill, because Michigan does now have a cyberbullying law, and they also did have a misuse of telecommunications law, which some police officers were using before there was ever, the bullying prevention bill. But I think a lot of parents don't still understand the gravity of what social media is doing to the students and how quickly things can really get out of hand, especially when we start talking about, certain language being used, images being transmitted. Then it goes into a compound state of where, a student can get into a lot of trouble rather than just harming the individual that they were trying to harm.
And honestly, from the suffering student's point of view, truly, I think that people my age didn't grow up in this era. And I think it's hard to understand that a very large portion of your world could be unavailable to you, or you could be subject to ridicule, and you could feel like less of a person. So the dangers out there are great. And again, what you do about it, obviously, there can be criminal liability and so forth. But with schoolmates, that's a big issue. And if parents can help students to understand that when this happens, they want to know about it. But that requires a good relationship, of course.
It does. And I think every time we get into a situation with a parent and their child who is kind of the victim or the target of bullying, be it cyberbullying, physical, emotional, it's always very difficult because the student doesn't want anybody to know. They don't want to be the person who told on the other person. So it is a very delicate tightrope. But I think more parents have to understand that we do have to have that conversation. I mean, when Matt was assaulted, I had that long conversation with him, and he wanted to kind of move forward, with those charges. So it's not easy, but as we've learned, going through a trauma, you have to have someone there on your side who is going to kind of help you through this. So I think also, not only what can parents do, on looking at the things that are in the state law, what can the state Department of Education, is there something more that they could do? I mean, you said earlier that they could, recommend that this happens, but do they have an ability to ask for these reports?
They could. I believe they have the statutory power to require that kind of reporting, but the proposed statute goes farther and requires a report to the legislature annually. Personally, if I were a school district, I would not want my name on a list of people that were not complying with the statute. But I think the problem is a little more subtle than that, Kevin.
Right.
I think I did my own little survey around the state of which school districts have websites describing this, and most of them try to do it.
Right.
I think where the Department of Education and all of us could help is to say, fine, you wrote it down. Okay, that's a good step. How often do you really get reports about this? Because every parent in the world knows this is a real problem. Right. If you're telling me you haven't had a report of a claim of bullying in years, I just would have to say, as a parent, that doesn't seem like real life to me. There needs to be some reason discovered as to why people don't feel like coming forward, or why you are not reporting them in any event. So communication, both from the department, okay, maybe providing model ideas about how to publicize the policy among parents and students and administrators and all of that, and then some pretty serious critical analysis of a district of itself and its people. There was a revolution, Kevin, in employment harassment in this country, and people said all of the same things. This is overdone. There's not that much of this going on, and so forth. And what we found out is it's not overdone. There is a problem out there. We talk about it. We have policies to address it. And the most basic thing in the world, just like with Matt's law, you have to report this as a supervisor or manager, and you are allowed to report this, should report this, if you're an employee, to a designated person or set of people, and you have to do training on it. Those are common sense ideas.
And I think, there and some questions are coming in on the chat and some comments that are good. And there was somebody, because what you talked about, we had over 250 schools in the state of Michigan in their last report for 2021 who reported they had 0 instances of bullying. And those are K through 12 districts. Those are thousands of students. So it is important to report it. And there is someone who's just said, I'm in one of those districts that did report anything. How do I do this? Who do I report it to? And should I? And is that being a whistleblower? But I think they should be able to report that. But who would that be if a school hasn't designated a person?
Well, first of all, it should be reported to the superintendent, just as you said. That person's responsible for everything that happens there. There would be nothing improper about telling the Department of Education about this. But in addition, and I think you talk to the principal, you can instruct an email, you could ask for a meeting. Obviously, you can go to the quarterly or semi-annual board meeting. And honestly, there's nothing un-American about this. This is as American as apple pie. You get up in that board meeting and you say, really? Okay, years have gone by and nobody's bullied anybody. You bring the lumber to them because no one's going to believe this. I think the administrators have to turn around and say, is everybody just worried about labeling someone as a bully? Is that what's going on here? So we divert it before any kind of label is ever applied. I think you have to ask, who are you really helping there if you take that approach? And a lot of questions have to be asked about why you have your head in the sand that badly.
Yeah. And people are also asking, is there like a centralized, form that, students or even teachers can fill out in their school? And that's a question for all of you that are on board listening here to go back and ask your school, because yes, there should be some type of procedure to report an incident. And they've had this for the last 10 years or more. There should be a system, and for you to find that out. And I think if your school doesn't have it, it's your, as Carey just said, it's your responsibility to ask why, to do the due diligence, for the students that you have. So, and people are asking about also anti-bullying programs. One of the things that we set forth in this law was a guidebook, and there is also a list of encouragements from the state of what schools should be doing. And those are bullying prevention programs, restorative justice. What it is up to your school to kind of build a program. There are thousands of bullying programs that you can go and purchase, but it may not work for you. I know people who have bought very expensive programs and it fails because it takes too much time. It takes too much time away. Build what's best for you. So, but your school needs to be kind of working on these levels.
Yeah, I would, by the way, if I were trying to communicate, I would think of 10 different ways to involve people, training, these kinds of programs, arming, basically restoring their sense of agency about the people that they go to school with. I'm going to take responsibility if I think a friend is in trouble. That's asking for some maturity, but a lot of our children really have that. But I would recognize that human beings communicate in many different ways. Some of them will send an email. So you'd have that, an email address that's going to a designated person, put it in your policy. You report it in handwriting at the school office or the superintendent. You can call a hotline. A hotline's a good idea for a school district.
Yeah. And I talked earlier, even with our earlier guest and Rashida this morning, there are schools I advocate do anonymous reporting. I've been to schools, they set up what they call hero lockers or hero boxes, and students can write notes about what they see, what they observe, and have a dedicated person go through those. Because if students start to see that people are taking, these notes to heart and helping, it's over a year with some schools, you start getting good information. But, and I have other things in the chat of, bullying's a real issue at our school, but students are told not to report it, let the staff handle it, but nothing ever happens. So I'm sure teachers are tired of going round and round in this, but your students are tired of this, as well. Somebody says kids are told cyberbullying is not under the school's responsibility because it happens off campus and after hours.
Well, of course, under the statute, that is not true. Many school districts and schools are issuing laptops nowadays. If it happens in that context, the statute would reach it. But to be fair, the absence of that provision, in other words, the exclusion for devices that are controlled or owned by only the student or the family, is an issue that is sought, that the sponsors of the legislation are attempting to remedy by broadening the definition.
Yes, and I think that, and I've always kind of said, even to schools before, when the law was in process of being passed, when they said, well, it's all free speech, it happens off school grounds. I'm a person who says, but what it is, it's an interpersonal relationship. And no matter if that interpersonal relationship is an argument over a football, sooner or later, it's going to end up in your school. And you'll have to kind of somewhat address that.
I think most parents would reject the notion that because we own the device or the other family owns the device, nothing can be done. Okay. Employers, for example, all the time address off-duty incidents between their employees.
Exactly.
whether they just left the premises, they're on the premises, they're in the car, whatever. They feel that they have a responsibility. So even if you couldn't bring it within the confines of the statute, you could say, now wait a second, do we really believe that allowing one of our students to be subjected to this kind of treatment is something that our district should stand for? And I think a lot of people would say no. Now, you have the problem of parents who are defensive about their child being accused.
100%.
And honestly, one of the few emotions involved here that I understand is that we don't want to see our child accused of that. But they have to say, I really, I don't care whether my daughter or son was using a phone owned by the school district or not. How does this bode for the development of my child that this could be accepted? And it's hard because we all tend to be a little bit defensive. The other person's to a degree responsible. They believe, and in some cases they're correct. Okay, but they need to take some responsibility. Both the district, the school, the principal, vice principal, whoever it is, and both sets of parents can deal with an issue like this, even if the phone or the laptop is not, or the iPad or whatever it is not owned or controlled by the school district.
Yeah, and I think that's also where the statute of there's the cyberbullying law also comes into effect, that there is a law in the books that this needs to be addressed. So that's out there for all parents and teachers, that if there is something going on, you do have that resource if you are, being held back, in some way by the school. Someone's asking, is it okay to say a reporting mechanism for the schools? It's more of a reporting mechanism kind of the state, that's kind of run by the state. It goes through the state police. And that information is then routed back to the schools. So there are also schools that have their own internal reporting system that never go to the state. But you can use that as a parent, as a godparent, as a guardian, to kind of at least maybe get the ball rolling and make, an inquiry to okay to say, and they do track that information. Personally, my idea is why I testified for okay to say was, if every school used that, think of the data we would have across the state of Michigan, where we would have hotspots, But okay to say is not just about bullying. It has actually saved lives of, children who threaten suicide. Those are getting into drugs, bringing guns into school. So it can be used across the spectrum. And if you are not getting anything from your school, I would, advise contacting okay to say as a way to get your message out.
Yes.
The one thing is, we had talked about, some changes, but somebody also asked, can a district avoid liability by following Matt's law?
Very good question. And it's complicated. I hope we can handle a minute of complexity. We'll live through it, I promise. The broad answer to the question is no, because it requires an explanation. If you complied with the statute entirely and followed up on the incident and reached a fair and defensible conclusion about whether bullying occurred and what should be done about it, you should not be liable. But notice everything that is in the answer. Having a policy, identify a person to enforce and receive reports about the policy, having a procedure, not retaliating. These are requirements, but they don't mean that you've done everything right. Take an example. You have a great policy and procedure. You've identified the individual to whom the report is made, but you basically let the report, the allegation go unaddressed for a year, and a child is injured or killed or something horrible happens again when this has not been properly remedied. The complying with Matt's law by policy and identification of the decision makers and so forth is not sufficient. That is one of the reasons the proposed legislation requires a quick turnaround of an investigation.
Yeah, no, but it is having that data to back up that you've done that, which I think where I know where sometimes news media has asked school districts for the data, and well, you have to file a Freedom of Information Act because we don't have that readily available. So it's I think it is for those schools who really want to be, understanding that they are doing everything they do, is keeping that data and having it readily available to be transparent. That's a big word. Everybody uses transparent today. So that to be transparent to other places. And someone asks, even as a parent, could I realistically go after my child's district if they're not in compliance? But I know that's a tough one.
Well, yeah, that's an excellent question. And I will tell you that it takes two to tango. You have to have the Constitution to complain, but we've gotten a lot better in this country and in this state about complaining when our motives are good in order to protect somebody. We complain when the airline mistreats us, for heaven's sakes. We can complain about this, but again, it takes two to tango. You have to have a district and a school and an administrator responsible for this that is willing to listen and do something about it, because it can fall on deaf ears. But the people who use the old adage, the squeaky wheel gets the grease, will understand this. You're going to get more done if you try to engage them, not nastily in the beginning, although there's a time for if things don't work, and then persist, stay with it, go to the meetings, ask for their help, ask them if they would be frustrated if this had happened to their child and what they would want to see done.
And to add to that, I have always advocated for parents in a district that are having an issue is to reach out to see if there are other parents, because there's also strength in numbers. If there are other parents or of your child's friend who's having issues, talk to those parents to get them also to go to meetings. Someone asked, well, should I just go to the news? Well, news loves a good story, but it has to be, kind of a real story, that there is, the facts behind it, and that can come out and kind of also put a spotlight, on you, put a spotlight on your child. So it's, again, as you said, takes two to tango. You need to be very, very careful about, some of those steps.
Yes, obviously there are defamation requirements in terms of a child or a family feeling aggrieved by a misstatement. You could report this without identifying anyone. That's probably a step that's far later in the process, because that's right. Not exactly an atom bomb, but yeah, it's a tactical nuclear weapon.
Yeah. And as someone who's bore the brunt of the media, it's always not the funnest thing to be in the middle of. So take it with a grain of salt. But so someone asked, do we have any idea how many districts are actually doing what they're supposed to do? Hard to say.
Yeah, I'm reluctant to say that they even all have a policy. I had trouble finding it on some website, which is the most obvious place in the world,
right,
where the policy should be placed. And if it's not there and it's buried, that ought to tell you something. But I will tell you, I think you know more about this than I do, Kevin. My sense is that we're a long way from total compliance with this statute.
Yeah.
And I think some districts are far better at this than others.
I agree. There are districts who are doing a fantastic job, whether they have all the pieces of the puzzle in place, but they understand why they're doing it, for the long term, and they're working on it. There are districts who are not working on it, and they felt, well, no one's breathing down my neck. I don't have to do this right yet. So, someone just said, why does it feel like no one cares until something happens? And I think that's generally our society. We're reactive. What we talked about two other speakers, we want to be preventative. And this is one of those areas that we can be preventative in having our policies and procedures in place. And if your district is only going through the steps, then ask somebody, why are we doing just the bare minimum? Why aren't we following all of these? So those of you as teachers and parents who are looking at this, and even if you're not here in Michigan, look at your law, compare that to what your school is saying they're doing, and then just ask them, show me what you're doing, so that it's the safety of all of our children.
Compliance people that worry in all industries about what might happen have the necessary state of mind. If you say to yourself, look, I don't know whether some tragic thing is going to happen if we don't properly take care of what we've reasonably discovered to be an honest and decent allegation of bullying.
Right.
We're playing Russian roulette. Okay. Yeah. If any serious compliance program has the state of mind, it doesn't have to be a tragedy in this case in order for me to feel that someday, soon or not, it might be.
Right. I think as people have it on their minds, as we know that the Oxford report, just the independent report just came out. And I think hopefully what I would take from it is maybe some schools look at that report and see somewhat of a reflection of what is their school climate, and see what they can do to, be looking down the road, not to have that potential problem. That would be my goal for school districts looking at that, and not hopefully sitting back and saying that's not us.
There's always something to learn.
Yeah. So I think there is. Is there anything else that from your perspective that you would like to leave with those that are here from your side of the aisle? Because it's always interesting. I loved our conversation the other day, and having someone who can speak on the legal side that people don't really understand sometimes is a fabulous tool.
Well, I think that the issue that you and I, from our discussions, Kevin, seem to worry about most is getting people from awareness to action. And I think that both the parents who need to be educated about this, whether their child is accused or not, or a victim or not, and the administrators need to say to themselves, yes, there are 10 things we need to be working on but this has got to be one of them, because when this goes wrong, it can go really wrong. So there needs to be discussion and communication and assignment of priority. Probably needs to be an administrator in every school district that's passionate about protecting children from a really awful experience or worse.
Yeah, I 100% agree with you. And someone just wrote that they were told by my district it was optional. This is not optional. This is a state law.
Well, since I don't know what school district it is, I can simply say that, this person should be presented a copy of the statute. I'm holding it into my hand. It's not some legal tome. It fits, although the type is small, on 2 pages.
Yep.
Right here. And even as it is currently described, it has some very serious requirements. So I would send a copy of the statute and as nicely as you feel you can, say it's not optional, it's something that we're required to do. And that is an example, I think, Kevin, of what we're talking about. The lack of information, to put it politely, ranges from outright ignorance, and that's a heck of an example we just to indifference, to I want to do the right thing, but I'm burdened, and I'm making a lot of progress, but I'm not all the way there. We need to work everybody all the way along that continuum.
Yeah, absolutely. I just put the link to the bill as it stands, for the law as it stands in statute, in the chat for anybody who wants to kind of go through and read it. And I think that would be beneficial. And as we kind of keep working on this, we will let people know. And who knows, maybe by the time we do this next year, we'll have something new in place, and we don't know. It's
right.
There's two things I've always said from my experience over the last 20 years. There's two things you don't want to see being made, and that's sausage and laws.
Yeah. Say that of the jury process as well. That's not pretty, and that's part of the reason, Kevin, don't want to put the following argument before the jury if somebody's really injured.
Yeah,
we did okay here. We had the policy. It was on the website, but we just didn't. We meant to get around to enforce our policy. Our hearts were not bad. When you have somebody who's seriously injured and you have a set of requirements designed to protect that person, you are not going to win an argument that you meant well.
Yeah. Yeah, very, very, very true. And like you said, we have to get everybody on board. So got a tremendous insight conversation on this. Thank you both. So thank you, Carey, for joining us. Very informative. I know we'll be talking again down the road and keep you apprised of what changes are coming. But for all of you who have been listening in, feel free to contact us, read the law, and go back and you be that change, in your school district, in your community, to become an advocate and ask sometimes the tough question. Yeah, as Carey said, bring the lumber.
Sometimes that's the only thing that's gonna do. And I want to thank you for having me and for the opportunity to participate in the discussion, Kevin.
It was great, and we will see you soon.